Good morning. Are you Federico Ortiz?
Yes, ma'am.
And will your client waive the formal reading of the motion and the indictment?
He will.
Mr. Ortiz, in cause number 25, DCCR 0589, you're charged with the state jail felony offense of abandoning or endangering a child, and that's from December 1st of 2024. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In that case, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Ortiz is not competent?
No, Your Honor.
All right, sir. In that case, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, in cause number, let me find it, 24, DCCR 2334, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 10th of 2025 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the months of May and June of 2025, and then also July of 2025. Is that true or not true? And then count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
True.
Then count 3 alleges that you failed to provide verification of completing the theft prevention class as ordered. Is that true or not true?
True.
And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I also have here on the tablet, in this case, some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over this with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes.
State tenders number 1.
No objection.
It's admitted. Mr. Ortiz, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm handing you the trial court certifications that shows that there are agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir. You can go back with the bailiff.
Thank you. Thank you, Your Honor.
Thank you.
And thank you, Mr. Rojas. Wow.
Randolph Vines, Mr. Rojas. Mr. Rojas is getting a gold star this morning.
It's been a while since I had one of those. Luke deserves to have to put out. Most of these cases are yours.
True.
Oh, well, y'all might have to share a star, huh?
That's right.
I don't require it.
I'll take the whole thing.
It's always nice to get a gold star.
Do I still have it? No.
Good morning. Are you Randolph Vines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Vines, in cause number 25 DCCR 1154, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but lead to charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the
Thank you,
bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, I've said it so many times. But I can't stop in the middle and then restart. That's not good. Lamone Yeoman, Mr. Rojas. Give me just a second. I'm going to print these out. They're both MTRPs, and it's just easier to find me. 19. Good morning. Are you Lamone Yeoman Jr.?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Let me get on. I should have another one coming also. Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct? And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building, and that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
Not true.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025, and is that true or not true?
True.
Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025, and is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So,
There's a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set, hold on. Anna, can you send me back 23-1556? I just sent it.
That may be the third degree paperwork. I think you may be right.
Yeah. Okay. I think, so 23-1556 is the burglary of a building,
Every state.
but y'all did TDC paperwork. And the other one, yeah. So those have to be right. So
We can read them.
I'm going to delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I got the numbers wrong. It didn't.
Okay.
I'm happy to redo them both.
Sorry.
That's my
Judge Raquel West catches a paperwork problem in real time and shuts it down before it turns into a sentencing mess. That may sound small, But in felony court, one wrong form can wreck everything. This is where precision matters just as much as punishment.
That's my fault.
All right, I'm going to delete both of those. All right, y'all just go have a seat in the jury box and we'll get that done. Let me delete that. I started, I was looking and I was like, wait a minute, that's because I thought it was a kappa 2 on the TDC case. I'm like, what? Okay.
Yeah, I forgot they were different levels. Luke taught the mistake. I thought they were different levels. That's all my
Okay.
fault. Do you want to plead Hendricks now, or do you want to do them when we do the other guy?
Go ahead and get that one done, and that way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Let's see. Mr. Kimler, you have Sheena Harmon.
Yes, sir. Judge, if I can, there's a lot of family members here on this side too.
Yeah,
With
which
Marvin,
one?
It's Christopher James.
Okay, I'll take care of it next.
Thank you.
Would y'all put that Christopher James sentencing up here for me to do next, please? Thank you. Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
Now the consequences get serious. Judge Raquel West accepts the plea and imposes 6 years for tampering with an electronic monitoring device, with prior felony history adding real weight. No theatrics here, just a clean reminder that violating court supervision can
Is
snowball.
it yours?
This is
Harmon.
This is
What did
Harmon.
I-
This
You call
is
Harmon.
Harmon.
Oh, that's why never mind. Just testing everyone. Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
Okay. And will your client waive the formal reading of the indictment?
So wait.
Okay, we're going on all of the counts.
Whatever
Or at
makes it
least-
third.
Okay, got
Whatever
it.
gets us to what they were judges.
Okay, I got it.
I think we're gonna need all of them to get us to.
Okay. Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic monitoring device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft, June 28th of 2010, and then you were also convicted of the state jail felony offense of theft on June 24th of 2013, and on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those
This is a high-stakes break for the defendant. Judge Raquel West delays sentencing for a pre-sentence report, but the warning is loud. Probation, restitution, and outside holds can flip this deal hard. So what matters more now? Second chances, or whether he actually
and
follows?
are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There's none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right
And
to
there it is. Judge Raquel West delivers the full 50 years in a devastating intoxication manslaughter case, tying it to repeat DUI history, PCP use, and a life taken. If this case hit you hard too, like, share, and subscribe for more courtroom breakdowns.
your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Yes,
All right, good luck to you, ma'am. You can go back to the